Parent rights for special education in Kansas. Parents should be active members of a student's special education team and be able to provide input and ideas at all meetings. A parent is defined as biological or adoptive, someone who is acting in the place of a parent, the legal guardian, or someone who has been awarded educational advocate for any student. In the case of divorced parents, all forms should be provided to both of them. However, consent is only needed from one of them. If a parent has an opposing opinion, they can request mediation or file due process, but the student will receive the services that the one parent agreed with until a decision has been made. Parents are provided with a copy of a physical handbook of their parent rights. They get it annually, and they get it when it's an initial referral, if there's a formal complaint that is made, if a student has to be removed from the school for discipline reasons, or upon request, the parent can be provided with a copy of those parent rights, and it should be in a language that they understand. For any special education process, parents have the safeguard afforded to them through a form called a prior written notice. And it is provided for a student who is identified as having an exceptionality. And they're provided when an evaluation takes place, the parent gives consent. If that student is indeed placed in special education services, parents are giving that notice. Also, if there's a change in special education service, whether it's an increase or decrease, if it's more or less than 25% of what they received before, a prior written notice must be provided, and also if there are any other changes. So what's on a prior written notice form? You have to be quite descriptive and list out what action you're proposing, why you're proposing it, list all the evaluation tools and assessments that helped you come to that conclusion, and just any other factors. On that form, parents will be able to acknowledge that they were provided a copy of their parent rights and are aware of them, and then they can give consent or deny consent for any of the proposed services. There's also a separate prior written notice that is used for consent purposes to conduct evaluations. On those, you have to make sure that you clearly outline what type of evaluation, whether it's an initial or re-evaluation, and then list out all of the evaluation procedures that will be used. Consent has to be informed. Parents should be made well aware of every action that the school is going to do for any process. Has to be in writing, is voluntary, and the parent can revoke their consent at any time. So when is consent required? Whenever you want to do, if the school wants to do an initial evaluation or conduct a re-evaluation, you have to get the parent's consent. After the evaluation, if the student is initially determined eligible for services, the parent has to give consent. Again, for changes, 25% increase, decrease, or more. If you want to add or remove a service, if a private school wants to do an evaluation, if any outside agencies are invited to meetings, schools can receive reimbursement for Medicaid for certain services. And so in order to do that, the parent must give consent for that. And if the school wants to use a parent's private insurance for any type of reimbursement, these are all things that are required, that will require parent consent. When is parent consent not required? When are those chances where you don't have to get their permission? When you're using a review of existing information, not engaging in any new assessment, you can do that without permission because it's information that we already have. If a test is administered to all students in a grade level or class and no consent was given from any other parent, then you don't need the consent of this parent in a particular situation as well if all students were receiving that same assessment. Also, changes to a student's IEP that are less than a 25% change, you can do that without the parent's consent as well. There are times when you try to request their consent, but then for some reason you're not able to connect with them. If the parent doesn't respond, you just have to make sure that you have tried to make 2 different contacts using 2 methods. So that could be phone and email, phone and snail mail. You just have to keep record of the attempts that you made. Parents can revoke consent at any time. It can be partial or for all. Special education services can occur at any time. The local education agency can try to resolve the issue with the parent, but ultimately it's still the parent's decision, and then the school must provide the prior written notice indicating that the revocation of services will take place at the requested date. Meeting notices must be provided to parents within 10 days of advance notice, and a meeting notice should have all of the things listed here on them. You have to know the purpose, date, time, and location, making sure that those are all convenient for the parent. Should list all the people attending with their titles, and parents can invite outside agencies, and you can list them here as well. And if a student is transitioning from Part C, they are doing their coming from infant toddler services, 0 to 3 services, into school district services, then that coordinator who is helping them through the process can also be invited and listed on the meeting notices. At the age of 18, students become what's called the age of majority, and they become their own education decision makers. And at that time, notices are provided to both the student and the parent. This was just a quick explanation or description of parent rights for special education in Kansas.